We're going to talk in this segment about preparing the deponent to testify, and it's a subject that is not talked about very much. I think people tend to focus on what's actually happening in the deposition rather than on the preparation of the witness to testify. And I think of it as the hardest part of deposition practice because you have to anticipate the various lines of attack that the other side might take, and to use the Army's expression, or paraphrase it, you have to make your witness all that he or she can be. That is, you have to accept the limitations of the witness and try to maximize the advantages or assets that the witness has. And unlike the interrogator, if you get into the deposition and things are not going very well, you as the defender are not in the position to change course and decide, well, I'll take a different tack. This one isn't working. You have very limited weapons in the deposition. You can object, but you're not supposed to make a speaking objection. And very often, making an objection and an objection and an objection will do nothing other to alarm your witness and make him or her more nervous. You can also give an instruction not to answer, but you can do that properly only in very limited circumstances, either where there's a privilege involved or where there has been some court-ordered limitation upon discovery, or if you're giving the instructions so that you can apply to the court. So for all practical purposes, that weapon doesn't exist. Consequently, my own approach in working with newer lawyers is that I will let a less experienced lawyer take a deposition before I will let him or her prepare a witness to testify. So what happens at witness preparation? First of all, I'd like to find out from the get-go what concerns the witness has. And I think it is best to start with the idea that the witness does have concerns. And so rather than saying to the witness, do you have any concerns, I put the question in terms of what concerns do you have? And I do that because I want to deal with whatever it is that's bothering the witness up front. Because if you don't deal with it up front, the witness is going to be preoccupied, distracted, etc., until you finally get around to it. So, for example, if the witness is concerned that he has a DUI conviction that happened when he was a junior in college and is concerned about that coming up in the deposition, you want to surface that first and deal with it first, and be sure that the witness is satisfied with it, and then say, okay, let's move on. If there is an attorney-client privilege, tell the witness that, and tell the witness what it means. If there is no privilege, tell the witness there is no privilege and what that means. And even if there's a privilege, I tell witnesses that you really ought not to be saying things here that you would not want to be asked about in public. So, for example, you don't want to refer to the other side as a group of slime balls. First of all, you're supposed to be practicing what you're going to say at the deposition, and you don't want to say that. And secondly, you never know, and you don't want to be in a situation where somebody says to you, have you ever described the other side as? And then you're in a completely unnecessary battle about whether the privilege applies. Tell the witness what the case is about. That it may seem that, well, the witness will know. I'm meeting with the plaintiff. I'm meeting with the defendant. Surely they know what the case is about. But the lawyer lives with the case a lot more than the client does, typically. And this meeting, you've reviewed your file, you've reviewed the allegations, you've reviewed the denials, you've taken a look at the preceding discovery, etc., you have the case fresh in mind. The client may have looked at this the last time was 6 months ago, so take the time to say, this is what the case is about. Very often, there are facts I want to know before we get going with the preparation part of the meeting. And so I will say to the witness, look, we met before and you gave me your information about this case. But there are some other questions I have now. So I am just gathering facts at this point. I just want you to give me facts in response to my questions, just as we did the first time we met. And when that's over, then tell the witness that's over. Now we're going to get to what the deposition is all about. I like to tell the witness early on what the physical layout will be and what the rules will be, or simply what the setting is, because I think people may have questions, may be uncomfortable about that. So I tell them, we're going to go over to so-and-so's office, we'll be in a conference room, I'll be there with you, the other lawyer will be there. I think the questioner will be Mr. A, but it may be Ms. B. Don't worry about who the questioner is. Either way, you'll deal with the questions as they come. This is what the seating arrangement will be. There will be a court reporter present, and everything will be taken down word for word, the question and the answer. And I tell the witness, you will be under oath. On 2 occasions I can remember, the witness on the other side walked in, we were about to start the deposition, the reporter took out a Bible, and the witness said to the lawyer, his own lawyer, you didn't tell me this was going to be under oath. You want your witness to feel comfortable, not uncomfortable. And if the witness does not take an oath, you want to find that out ahead of time so that that can be handled smoothly at the deposition by just telling the reporter ahead of time. Just ask this witness to affirm or even to write it down for the reporter so that he or she can read it. I talk to the witness about what does it mean when people say, let's go off the record, and tell the witness that from his point of view, her point of view, nothing is off the record until I tell you it's off the record, and I'm not going to tell you that until we are downstairs outside the other fellow's building on the sidewalk. And I might not tell you then. I might wait till we get back to my office. But anything you say during the course of the day, even off the record, you can be asked about. I talk about how should you conduct yourself during breaks. What about small talk with the interrogator when you find out that, excuse me, that his daughter is going to the same college as your son? And I say what it means when I object. Don't be distracted by that. I'm doing that simply for purposes of the record. You will then be told to answer the question, and then answer the question. It's very unlikely, but I may give you an instruction not to answer, and you may be asked if you're going to follow it, and the answer is yes, you will follow my instructions. I might get into trouble if I'm wrong, but you will not. And then what the end product will be. The end product will be a transcript, or will be a video that can be shown, played at trial, and I'll have a transcript there to let the witness see what it ends up to be. We all have our rules of the road for the witness as we get into witness preparation, and I have the benefit of having John Azenbray's rules of the road written out in front of me, and I'm going to read the headings on them. On each of these, there's a lot of follow-up, and in a real preparation session, any lawyer would follow up on each of these points. But I'm just going to tick through you and give you the heading. Tell the truth. Listen to the question. pause between the question and the answer. Do not guess or speculate. Do not volunteer. If the question contains an assumption, you must deal with the assumption first. Maintain a business-like demeanor. Do not be overly concerned with inconsistencies. Be wary of demands for precision. Avoid hyperbole. How documents will be used at the deposition. You are entitled to give a complete answer to each question. Beware of questions about how things are normally done, and you are in control. And I should say that these, I think, are what I think of as a traditional way of preparing the witness to testify. If you took 10 other experienced trial lawyers and put their scripts next to this one, there would be very apparent similarities, I'm sure. Dave?
Well, let's talk about some of those similarities, but also differences. And one of the most common instructions given by attorneys to their clients is the instruction of do not volunteer. Some lawyers will give the same type of instruction, but state it in the way of keep your answers brief or keep your answers short. One attorney I'm familiar with uses the instruction, give the shortest truthful answer. And for many years I have omitted that instruction or similar instruction from my coaching because I have found that witnesses tend to overemphasize it. By far the most important instruction is to be truthful. We know that most of what we are doing is designed to assist our client in being truthful and to avoid the pitfalls that are inherent in the other side's questioning, much of which is designed to cause our client to be untruthful in a manner which they can then demonstrate. And so if our goal is to help our client be accurate and truthful and honest appearing in the testimony, we don't want to give instructions which they might misunderstand. And this instruction about keeping answers short, I have found to be the single instruction which is given too much emphasis. And when a witness is faced with the question in their mind of whether they should give one more sentence to their answer or stop at what they have said so far, as between your instruction to be truthful and be short, they tend to be short rather than fully truthful. And I ask myself, which would I rather have them fail at, brevity or truth? There's no doubt we want our witness to be 100% truthful, and if all of the other instructions are missed, we can deal with. But the absence of truth, we can't. So I've deleted the do not volunteer or keep it short or keep it brief or any similar instruction. That's not the majority view. I think the majority of lawyers still counsel on, as you have explained, but I wanted to express my concern. The other coaching that I give that isn't on this list is how to deal with leading questions. I want to make sure that the witness knows that the other side will be able to ask questions which not only ask the question but suggest the answer, and that my client has the right to use his or her own words in answering the question, even though different words are being suggested, and that because their obligation is to be truthful, if a simple yes or no isn't the most truthful answer, they should use their own words to be truthful rather than think that they have an obligation to accept one of the alternatives that have been portrayed by the opponent. So those would be my additions and modifications to this list.
David, I agree with your point on do not volunteer, and the way I use do not volunteer in a session where I'm meeting with a witness is to explain that you need to give a truthful answer and a complete answer to the question. But what you don't want to do is try to anticipate where the next question is and try to answer it in advance, or try to answer the question that you think he should have asked instead of the one that was asked, because you're not really. Witnesses frequently do that, especially busy executives. They do that because they think, well, that'll help this thing get along, to get it over with, because they have other things they want to do. I think it's better if they just answer the question, make sure they've got a complete answer, and stop. One of the things that we've talked about in other parts of these presentations is something that I do frequently in a deposition. When a witness finishes an answer, I'll just look at him, anticipating that, nodding my head in a way that suggests there must be more to say. And inevitably, the witness will fill that silence, and they will start to say something. And my view as a deposing the interrogator is the more they talk, the better I like it. So when I tell the witness, I don't want you to volunteer, it's more in the sense of, give them your answer, make sure it's done. When you're done, stop. Don't try to anticipate another question. Don't try to figure out, well, if I just tell them this, then this will be over. And wait for the next question to come. That's what I mean by
Well, I certainly don't have any concerns about the do not volunteer instruction if it is coupled with all of that explanation.
Yeah, it needs to be.
My concern is that some lawyers overemphasize brevity rather than what you're explaining, which is answer the question which is asked of you, but only that question.
Right. Yeah. I had one other point I wanted to make, if I could, Dennis. I also find a lot of times when you meet with busy executives, it's often they've only been deposed once or twice before, but occasionally, especially with experts, you meet with a witness that's been deposed 50 or 100 times, maybe more times than you've been in a deposition. And it's very hard to prepare that kind of a person because they think they know everything, and they're not even listening half the time when you're talking to them. And I think you really have to break through that and make them understand that in a deposition, the ability to know what you're thinking and how you're doing your job will help them understand, instead of them thinking, well, the last time I was with a lawyer, he would always throw in an objection, and that would be my cue that I needed to think about something. I don't do that. I hardly ever object if I can avoid it. In fact, I tell the witnesses, if you're doing a really good job, at the end of the day, you're going to wonder why I was there, because I didn't say anything all day. And so that, I think, is important, to make sure you get over your witness's experience level and make sure that they know they have to be paying attention to this preparation session.
Let's spend a moment talking about that, because that is a really important issue of how to deal with the witness who has experience and believes he or she already knows how to do this. Mm-hmm. I always ask I ask every witness about their deposition experience.
Sure.
And if they are an experienced deposition witness, as many experts are, I ask them how frequently they have been prepared by lawyers on how to testify. And many of them say that they've never been prepared because of the assumption that they were already good at this. And I then ask them, would they be interested in learning how to be a better witness, and try to get them to tell me they want to hear this. And many of them ask me to give them the assistance at being an expert witness. One of the things that I do is go to experts' seminars, their conventions, to talk to them about how to be better expert witnesses, because they are interested in this subject. Yeah. So I try to get them to ask me to help them. If they are resistant to training, if they say, I know how to do it, I've been trained, I don't need it, I tell them that there are differences in training techniques, and before I represent them as a witness or present them as a witness, I want to know what their training was. So then I ask them to tell me what they know about each of these subjects so that I can hear what their training has been. Most of the time, they have most of these things right, and I have them tell me what they understand to be their technique. But if they come to a point where I have a difference between what they have been doing and the way I like to have it done, I express my differences. So that's the way I deal with someone who is telling me they don't need the training that I'm going to give them anyway.
Well, a variation on that problem is the witness whom you've prepared to testify on a half dozen other occasions, who comes in and thinks that he does indeed know it all.
Right, remember it all.
And one of the gimmicks, I guess, that I use in preparing a witness is sometimes is to say to him that you're like a hockey goalie in an ice hockey game, and your job is not to score points. Your job is to block shots. And if you decide you want to skate down the ice and score for your team, it's going to be a catastrophe. So if I'm running into this same witness again and I say, now let's go over the ground rules, I will often get, you're going to tell me about the hockey goalie again, right? And my answer to that is, look, anybody can have a bad day testifying. So I want to go over these rules again one by one and refresh you on them, so that if at the end of the day something goes wrong and you had a bad day, you and I don't have to look at each other and say, we were just too lazy and that's what happened here.
Right, that's a good point.
And people then are willing. They understand that, yeah, we all need to be refreshed. Let me make a more general comment about witness preparation, and I said at one point that these are the traditional instructions that are given to a witness who's about to give a deposition. Let me take a different kind of witness that you would be preparing. Let's suppose that you represent the defendant in some case, and you've received notice that the plaintiff is going to call your client as a part of the presentation of his case. He's going to call your client as on cross-examination. In that situation, I don't think anybody would prepare us to testify by giving him or her the instructions that we just reviewed for a deposition. I think at that point we would have in mind that, look, we want you to be a champion. This is an opportunity for us. The other fellow is calling you because he thinks you can provide certain facts that help his case. So the questions come, answer the questions, but you may see opportunities to go a little beyond the question or to elaborate upon what your answer is. And don't pass up that opportunity. And there are two reasons, I think, to take that kind of an approach with a deponent. That is, to try to make him not just a defender, but to try to make him a champion to carry the standard into battle. One is reflected in an article by Stephen Lubet about a decade ago, where he made the observation that 95% of the cases settle, or maybe it's 90, whatever it is, a high percentage, and it's based upon how each side sizes up the other's witness. If you have a really good witness on your side of the case, why limit him or why limit her? Let the other guy know, we have a really good witness here, and you ought to take this into account in evaluating the case. And the other situation is, I think when the witness is being videotaped, that you want the witness to, I will say, resolve doubts in favor of saying more, because you don't want the witness coming across as tight-lipped, etc. And I don't know whether you agree with that, John, or Dave, or have different thoughts, but that's my own take.
I agree with, I should have mentioned that when you'll always know if it's going to be videotaped because the notice has to tell you that. And if it is, the preparation is a lot different because you know they're videotaping your witness, possibly because, especially if it's one of your executives or officers of your company, because they may want to play it. And so you do have to give them a lot different preparation and monosyllabic yes-no answers. Going back to David's point about leading questions, I try to tell them the best way to answer leading questions is to restate the answer in your own words as an affirmative sentence instead of saying yes.
Very good.
You use your own language to say the answer. It helps them, by the way, in dealing with pacing, because, you know, if they get a series of leading questions, yes, this, didn't you do this, yes, didn't you do that, yes, you can slip into that and you're not paying attention and you end up answering a question yes that really shouldn't have been answered yes. But if you stop and you answer with an affirmative declarative sentence, that makes it more difficult for the questioner to get you into a rhythm.
I think it's critical that the lawyer, before beginning the preparation of the witness, give consideration to the goals of the deposition. Mm-hmm. And there are two alternative typical primary goals. One is to strategically prepare for trial. In other words, to have your witness perform as well as possible, to do as little damage as possible, and prepare in the other side's attempt to utilize this deposition as one of their trial tools. But often, the more important goal of the deposition is to facilitate settlement, to give the information that the other side is lacking about the quality of our witnesses and the strength of our story, so the other side will change their prior evaluation of the case to one which we consider to be more reasonable. And many of the instructions that are typically given are aimed at the first of those two goals and not the second. And we really need to think about what's our goal here in this deposition. Even though it's the other side's deposition, we ought to establish our goal. And if our goal is to use their deposition to educate the other side to the strengths of our case, rather than to avoid their development of their trial tool, then we have to coach our clients accordingly and encourage some of the things that you have just been talking about in order to help them get the story out within the confines of the questions that are going to be asked of them. The other thing that I think that's really important that was just touched upon, but I'd like to add, is the importance of knowing our client and the questioner. In the conversations that Dennis has suggested that we have with our client about reviewing the story, we'll get a good sense about whether our client is prone to overstate or understate, whether there's somebody who's shy about the important issues or tends to want to exaggerate them. And we need to, again, retool or structure our coaching in order to bring them to the position that we think is most likely to advance our goals. Also, we ought to know the questioning style of our opposing lawyer so that we can help our client know the kinds of techniques that are going to be used against him. And if the opposing lawyer tends to be solicitous and friendly, to try to get our client's guard down, we want to warn them about that. If they're the more traditional, hard-charging, accusatory technique, we want to warn our client about that. We don't want our client to be surprised about any questioning technique that we already knew about.
Mm-hmm. Dave, you've mentioned a couple of times coaching the witness, and very often you hear lawyers say that it's okay to prepare the witness, but you can't coach the witness.
That's not a semantic difference that I think is significant. I think the reality is we are like a sports coach. We're like the champion tennis player's coach or the gymnast's coach. We're helping that gymnast hone her skills. and give that appearance that makes her takeoff or her maneuver and the landing be as perfect as it can be, and that's done by coaching. And I'm not ashamed to say that I'm a coach.
There's one other thing that I would mention, and it's something that I've used only with, I would say, pretty sophisticated witnesses, and that is, I went through media training some years ago in connection with an interview that was going to be on 2020, and one of the ideas that was mentioned was that you should not repeat the faulty assumption when you answer a question. And to give you an example of what that means, if the question is, did you fire Ms. Johnson because she was pregnant? I used to think a very strong answer would be, I did not fire Ms. Johnson because she was pregnant. And the message was, that's not a good answer, because while it's literally fine, what you have done is to repeat the faulty assumption, which is you fired her because she was pregnant, and that it was better to answer the question, we fired Ms. Johnson because we received so many customer complaints, not for any other reason.
Well, I'd like to add a couple of additional points. One is the question that many witnesses get about what their preparation was for the deposition. I think it's important that if we have used a document to help refresh recollection, we know that there's a high likelihood we're going to have to produce that document if it was not previously produced. We've probably waived privilege under most states' rules. If, on the other hand, we have been sensitive to that waiver issue and have discussed a document with the client but not showed the client the document, we need to help our client understand that distinction, so when they're asked if they used any documents to prepare for their deposition, they don't incorrectly indicate that they read a document which we really didn't allow them to read. We also need them to know what they should and should not be saying about their preparation. The fact that they met with us, the day in which they met with us, and even the amount of time they spent in their meetings with us, we know they're going to have to disclose, but we also know that the content of the discussions are privileged, and I tell my clients that so they know what there's going to be expected to have to talk about and what they are not. I also like to ask as a summary catch-all question with my clients, whether there is any question that we have not covered that they are worried about, that and particularly that they are worried that they might be tempted to conceal the answer. And I say that sometimes there are things about people's past that are not relevant to this case, but I know that clients worry about might come up, and if we haven't touched on anything like that now, but you are worried about something being revealed, let's talk about it now, because I can deal with it if you warned me about it. There are lots of things I can do to keep you from having to talk about those kinds of issues, but if I don't know about it, I can't help you. So I ask a catch-all question designed to tell me whatever it is the client might be worrying about being revealed and therefore might have been tempted to be untruthful about. I think the last issue we should also discuss is the extent to which we want to put our clients through a practice Q&A session. We've talked about what our coaching is, what our instructions are, how we try to teach our clients, but I would ask both of you, how much practice do you actually do with your clients? Do you do sample questions and answers? Do you have somebody from your office come in and attempt to portray the style of the opposing counsel? Do you videotape any of this and show them how they're actually doing on video, particularly if it's been noticed as a video? What are your routines and practices?
I think a practice Q&A is effective and useful. I try to get another lawyer in my office to do it, particularly if it's going to be an aggressive deposition or a cross-examination, because I want the client to realize I'm their friend, I'm on their side, I'm their advocate. And if I drop into the mode of being the other guy and attacking, that can be a little unsettling to the client. And I think it's better if they see me as the person who's there for them. And this other person, one of my partners can come in, or an associate, and role play that question and answer. I think it's a little better. It also helps the witness, because if it's me doing it, they'll drop out of role quickly, or I might even do it, and then they get confused. What's really going on? I can remember videotaping a preparation session once, I think, in my life. I think it's a dangerous thing to do, because if it comes out that you did it, minimally you're going to get involved in some sort of motions practice over whether they have a right to see the videotape. I think you should win that practice, but it's just troublesome to do it. It might be useful to put them on camera and let them see themselves live, but not tape it. But I don't think it's a good idea to videotape. Dennis?
Yeah, I practice, of course, with the witness, and I typically do it myself. I've sometimes had somebody else in the office do it, but recognizing what John says about sort of keeping lines straight with the client, that I'm for you and somebody else is against you, I nonetheless generally do it myself. One gimmick I've used to kind of keep straight with the witness where we are at any given time is to say to her, let's suppose her name is Mary Johnson, is to say, look, when you and I are talking, I'm going to call you Mary. When I'm the lawyer on the other side, it's going to be Ms. Johnson. And it becomes a useful cue. You say, all right, Mary, let's talk about that last answer, da-da-da-da. Okay, Ms. Johnson, da-da-da-da. And people get it. Mm-hmm. And as a matter of fact, when I slip, I will sometimes have the witness say, am I Mary or Ms. Johnson?
Right.
In terms of video, I have sometimes had the firm videographer come in, show what the setup will be, ask them a few questions, non-substantive, so that they get familiar with what the setting is. I think that's less of a concern today than a decade or more ago. I mean, videos are so ubiquitous. Everybody's been at the family party and reunion and so forth. I think they are less intimidating than was one time the case. Along one other point that I'll mention, and I don't know that it fits under this category or not, but it certainly has to do with witness preparation. A fellow I know in Philadelphia was telling me that he was preparing husband and wife defendants in a personal injury case involving a slip and fall on their property, where the plaintiff was injured as a result. And he was meeting with the two of them, and he said, now, early on, they'll ask you some background questions about your education, something about your family, how many children do you have, and so on and so forth. And he said he noticed that as time went on, that the woman was becoming more and more agitated. And at some point, he found an excuse to be talking to her only, with the husband not in the room. And he said to her, what is the problem? And she said, my husband and I have 2 children. I had one before we married that he does not know about. And these are people that have been married like 30 years. What do I do if they ask me how many children I have? And this fellow's answer was, I think you should interpret the question to be, how many children do you have by your husband, Mr. So-and-so? And he said later, when we were talking about it, that, you know, it was completely non-substantive whether she had 2 children or 3 children, and he just decided that was the right thing to do. I suspect there are people that would take a contrary view, but you run into some human problems.
But regardless of the answer, it was so important that the lawyer be perceptive to that concern by the witness. You don't want the witness to struggle with this on her own. And you don't particularly want the witness to be trying to figure out at the time of the deposition how to deal with difficult issues like that. So being sensitive to those kinds of concerns is the most important thing.
That's right.
And helping the client structure the truthful testimony or protect the client so that in some areas the client just won't have to get into the issue.
Just one final point, back to your, I didn't want to leave the impression that I load up the bill for my clients by bringing in an extra lawyer. I'm only talking about situations where you know that they're going to be in a really aggressive deposition and the other lawyer is going to be attacking and it's going to be a painful experience. I don't want them to experience that from me. Frequently, I like your idea of Miss Mary and Miss Johnson. That's a great tip.
Well, I think it all depends on the case. I've not only had colleagues in the room getting somebody ready, but on occasion I've had a jury consultant in the room to assist in preparing the witness to testify. And actually, on a couple of occasions, I've managed to do that without the client ever asking, who is this guy? He just introduced himself, and that was that. And I would guess he just assumed that it was somebody else from the firm. But that can be, you know, yes, it's an additional expense, but it can make the difference.
Well, we know that if there's one place where the client can lose the case, it's in his or her deposition. The rest of the time, it's our case to lose. But this is when it's their time to lose. And so putting a little bit of extra time or expense, whether it be a witness, a professional, or another lawyer from the office, this is the one place where I think we should make the decision to spend rather than save. I'll cut out taking an extra deposition to spend a little extra time to prepare my client for the deposition. This is often the most important thing that we do in a case.